Good morning, everyone. Happy Aloha Thursday. We have a number of measures on our agenda this morning, so I'll call the Committee on Commerce and Consumer Protection to order. Let's see, I appreciate seeing Senator Chang on the video. Welcome, Senator. Here in the conference room, I think Senator Favela is on the video, although I understand maybe his video is not on. There he is. Welcome, Senator Favela. Here with me in the conference room, Senator Nishihara, Senator Michalucha, Senator Riviere, and Senator San Buenaventura. And I'm Senator Rosbaker. So, we have a number of items on our agenda, so members, with your permission, let's get started. The first measure we have is, let's see, am I supposed to give any other announcements? Yes. We have all of the audio and video of remote participants is being streamed live on YouTube. You can find the links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website, www.capital.hawaii.gov. Let's see. You will be able to find this Zoom meeting and our YouTube live stream for this agenda today, as well as the one we had yesterday and future agendas. If for any reason, with technical difficulties, we have to abruptly end this hearing, we will post when we would reconvene, but most likely would be February the 5th, tomorrow at 9:30 and 2 to 9, because we have another hearing scheduled. We appreciate those of you who have submitted written testimony. You do not have to read your testimony. We have it. You may summarize, or you can be just available for questions. Let's see. Have I missed anything? Okay, let's get down to the bills that are on our agenda. The first one is Senate Bill 525. This is relating to business registration. It has to do with obtaining certificates of good standing, annual report, certificates of vendor compliance, and relates to corporations, nonprofit corporations, professional corporations, partnerships, limited liability company. Let's see, our first testifier is Mr. Tai Nohara. He is the Commissioner for Securities with the Department of Commerce and Consumer Affairs. Tai, are you on the call with us?
Yes, I am, Senator.
Good morning.
I'll be available for any questions.
Okay. All right. Any questions for DCCA? All right. Thanks, Tai, for joining us. And my apologies for misidentifying you. But thank you for being here.
No problem.
Department of Taxation. Director Choi submitted some written testimony. We have DLIR. Is Joanne Vindahar on the Zoom call this morning?
Good morning, Chair. Thank you, Joanne Vindahar. The department stands on our written testimony and we're available for any questions that you may have.
Okay, thank you so much. We have testimony from Tom Yamachika for the Tax Foundation of Hawaii. Tom, are you there?
Hello, Chair. Tom is not on the call today.
Okay, thank you. We have his written testimony, and we have testimony from Librata Kobian, testifying for AAC, and I am trying to see what that acronym stands for, and it's not listed in her testimony, or his testimony. Mr. Kobian, any comments or statements you'd like to make?
Yeah, just really quick. First of all, my name is Lee Kobian, and I'm a business owner. I'm a contractor of 30 years in Hawaii, in the construction industry and environmental also. I've been supportive of Bill 52, and you know, over the past years, I've encountered many entities and nonprofits that pretty much had many violations with taxes and Department of Labor, and I found it interesting that they were able to always be able to get a certificate of good standings. And so I thought that was strange. And I actually had a friend who came out of prison after 9 years for environmental crimes and tax evasion, and he was able to get he wasn't a friend, somebody I knew, but he was able to get a certificate of good standings. And I always thought that was weird. And so I looked into it, and I contacted the DCCA in the Business Registry department and asked them, how do these people get a certificate of good standings when they're not complying with some other agencies, like when you require a certificate of vendor compliance? Well, all they need is just the annual report, and then you pay your $5. You write down what you do, your agent's name, and a couple of officers, and there you get $5, and you get a certificate of good standings. And I thought that was kind of like misleading for an entity who's not compliant with other departments to get a certificate of good standings. And I think anybody who gets a certificate of good standings should comply with being able to meet the qualifications for a certificate of vendor compliance.
Okay, thank you, Lee, very much for explaining the rationale for the measure. Members, any questions for Lee or for anybody else that's on our Zoom this morning? If not, let's go forward then to Senate Bill 562 relating to deceptive practices. Clarifies that any person that offers free or reduced rate shipping to a consumer in another state but who refuses to honor that shipping offer to a consumer in Hawaii has engaged in an act that is unfair and deceptive under certain conditions, and it extends remedies. Let's see, for this one, we have testimony from Mr. Levins, DCCA. Good morning, Steve.
Good morning. We appreciate the intent of this bill, but we think there may be some unintended consequences, and that it could, in fact, disincentivize mainland merchants from actually shipping here to Hawaii if this bill causes them to ship merchandise at a loss. Obviously, they're not going to want to ship anything to Hawaii if they're losing money. But there's no question that people in Hawaii are disadvantaged when they order merchandise from merchants who just put like a flat rate, some kind of surcharge on shipping items to us in Hawaii. I mean, they may just pick out $15 because they're shipping something to Hawaii. It doesn't require any additional work. There's no justification for this. So we suggested some alternative language to try to address this situation. And it simply says that a shipper, whether they're shipping from Hawaii or they're shipping from California or wherever, the cost should reflect the actual cost of shipping. We're not asking the merchant to take a loss to ship to Hawaii. All we're asking for is some kind of transparency. And if it costs $45 to ship to Hawaii, and they want to charge a consumer in Hawaii $45, that's fine. But if it costs $12 and they're charging $25 just because it's Hawaii and there's no additional work involved in processing or shipping the merchandise, people in Hawaii shouldn't have to bear that cost. So like I said, we've suggested some alternative language, and we think that it would help consumers here in Hawaii. Thank you.
Okay, thank you, Mr. Levins. We have testimony from the Attorney General offering some comments, and testimony from Andrew Pepper in support. Anybody, let's see, we have no other testimony that's been submitted, so members, any questions for Mr. Levins?
Yeah,
Senator Riviere?
thank you, for Mr. Levin. Can we impose a penalty on these merchants or vendors on the mainland if they do, overcharge? What is our recourse in practical terms?
Well, you know, if there's a law on the books here in Hawaii and a merchant has the minimum contacts regarding doing business in Hawaii would have jurisdiction over those merchants. And it's not discriminating against mainland merchants versus Hawaii merchants. The way that the language reads, it's neutral. Anyone who is shipping stuff to Hawaii, if they're doing business in Hawaii by virtue of the fact that they're shipping something to Hawaii and they've accepted an order from people in Hawaii, all this law is saying is that you have to disclose what the actual shipping costs are, and you should charge the actual shipping costs.
Right, no, I'm in support of the intent of this bill for sure, and, because we do get ripped off all the time. I'm just curious, but in the practical terms, how do you go back and enforce it if they just ignore it? And, you know, can we potentially impose an additional tax or something on them? Is there a way to create a nexus like that? Tax on the merchant?
I guess my answer is that it wouldn't be any different from any other company that's operating from the mainland, assuming that the Hawaii courts have jurisdiction. If they're engaging in an unfair or deceptive trade practice that impacts people in Hawaii in this jurisdiction, we could file a lawsuit in Hawaii court, and they would have to defend.
Might we from the state have a process where we send them a letter of like concern, like don't do that again? Would that be easier than suing them?
Well, it really depends on the circumstances. Sometimes, for instance, if it seems to be an unintentional conduct by a business and there isn't appreciable consumer harm, in those instances, it may be appropriate to issue a letter advising them of the violation, the alleged violation, and ask them to go into compliance. There may be instances in which it's not worth or not appropriate to be sending any kind of warning letter. The underlying conduct may be so egregious and harmful to people in Hawaii that it warrants filing an immediate lawsuit. So it really depends on the circumstances. I mean, we're not here to create unnecessary work and costs for my office and, for the courts here. But if there is conduct that appears to warrant filing a lawsuit, whatever it is, we're going to do that.
Thank you, Chair.
Okay, any other questions? If not, members, shall we move forward to the next item on our agenda?
Yes.
And this is Senate Bill 193, relating to equitable gender representation on corporate boards. Requires publicly held domestic corporations to include non-male and non-female individuals among the directors of their corporate board. Establishes reporting requirements for the Department of Commerce and Consumer Affairs, as well as penalties. We have DCCA. Ty submitted testimony on behalf of DCCA. Did you want to add anything or stand on your testimony?
And on our testimony, Senator.
Okay, thanks, Ty. Hawaii Civil Rights Commission also submitted testimony in support. AAUW, Young Hee, I see you on the Zoom. Did you want to make some comments?
Yes, good morning, and Chair and Vice Chair and members of the committee. Thank you for this opportunity. AAUW of Hawaii strongly support this measure, and we stand on our testimony. Only comment I will make in addition is that I had chance this morning to read others' testimony, and I'm in total agreement with Civil Rights Commission that we should also look to expand this to include racial and ancestry equitability as well, in addition. And I do believe that Illinois has done so, and Massachusetts has passed the resolution a while back to do as well.
Okay.
So thank you.
Thank you very much. We have testimony and support from the Hawaii lawyers. Mihoko Ito. Mihoko, are you on? I see you there.
I'm here. Good morning, Chair and members of the committee. Mihoko Ito, just wanted to stand on Hawaii Women Lawyers' testimony in support of the bill. Thank you.
Thank you. We also have testimony and support from Carolyn Kunitaki, Jean Evans, Catherine Bukovets, Elizabeth Hansen, Kathy Lee, Janet Morse, and Ann Freed. And we have late testimony from the LGBT caucus of the Democratic Party of Hawaii in support from Michael Galoyo. Members, any questions for any of our testifiers on this measure? If not,
Chair, I do have a question. I'm not sure who to ask, but maybe it's just a quick one. Is it not overly prescriptive saying must be 3 and 3? Or, I mean, if there's 6 members or 7 members and we must have 3 and 3, might that not be overly prescriptive? Is there maybe somebody I should ask her?
I would comment that if you don't give people some direction, then they're not going to know exactly perhaps what we mean by equal representation.
Mm-hmm.
And as someone of a class of individuals who has seen that, I think it's not overly prescriptive.
Okay,
That's
thank you.
just the chair's interpretation.
Thank you.
Okay. Any other questions? If not, let's move forward to Senate Bill 201 relating to corporations. This would require domestic and foreign corporations to provide their shareholders with reports of independent expenditures and political contributions. We have testimony and support from the Maui County Council Chair, Alice Lee. We have testimony in opposition from the Hawaii Bankers Association. We have testimony offering comments from McCorriston, Miller, Mukai, and McKinnon on behalf of the American Family Life Assurance Company of Columbus, also known familiarly to us as AFLAC. And we have testimony in support from Kathy Lee. Is there anyone on the Zoom conference who I called and wants to provide oral testimony? If not, members, shall we move forward since there is no one to ask any questions of? The next measure on our agenda this morning is Senate Bill 320 relating to tax return preparers. Requires each tax return preparer to have a valid preparer tax ID number, identification number, issued by the Internal Revenue Service, and to furnish the preparer's tax ID number on any return or claim for refund if required by DOTAX. Establishes penalties for failure to comply, provides that tax return preparers shall not be liable for penalties prior to January 1, 2022. Do we have a representative from DOTAX?
Morning, Chair, Vice Chair, members of the committee. Tejen Sakata on behalf of DOTAX. We stand on our testimony in support of this bill and available for questions.
Thank you.
Thank you.
We also have some comments from the Tax Foundation of Hawaii. Members, any questions for?
Thank you, Chair. Tom Yamachika from Tax Foundation of Hawaii. The one thing we wanted to emphasize from our testimony is that the P10 is just a registration number. It can be issued to anyone who wants one, and we wouldn't want anybody to get the impression that P10s are smarter or more reliable or more educated than others, and it may be a mistake to give the public the impression that they are. I'm happy to answer any questions.
Okay, thanks, Mr. Yamachika. My apologies, I didn't recognize your face. We also have testimony from the Hawaii Association of Public Accountants in support for this measure. They note that tax laws that are not followed mean that the state will not collect tax money that is due to the state. And at this point in time, we want to collect all the taxes that were due. Any other comments from any of our testifiers, questions from members?
I have a question. Okay.
Senator San Buenaventura. Pull your microphone down so they can hear your You don't have to pull your mask, but your microphone.
Okay, Tom Yamachika, since you seem to be, or is there a DOTAX also present?
Yes, there is.
Okay, so my question is, maybe I should do it to DOTAX. What about volunteer tax preparers? You know, like there are AARP volunteers who try to help out seniors. Are they then, if we pass this bill, required to provide, to get a tax preparer identification number?
Senator Bonaventura, this PTIN requirement is only for preparer that they receive compensation to prepare any return. So the requirement is for any paid preparer.
Yes, Senator, I would agree with that. If a federal tax return is prepared by VITA or some other program with volunteers, there is a way to identify that on the return, but a PTIN is not required.
Okay, thank you.
Thank you.
I have a question, Chair.
Senator Ms. Aluja.
Tax Foundation, perhaps. Do you think that the penalty that is offered in the bill is sufficient? Because it's on the low side for me, but I could be wrong. If we're trying to establish and, the fact that we're serious about this, $100 for a violation may be on the low side. But again, I'd like to get your insights on it.
Thank you, Senator. $100 per violation may be a sufficient deterrent if the preparer is doing a lot of return. The one thing we don't know is how much the $100 is going to be multiplied by.
So, in essence, Mr. Yamachika, you are saying that if a tax preparer is making the mistake on one return, they're probably making it on multiple turns and would be, they would be having a series of violations.
Yes, that's correct. If they're just not putting their preparer number on the return, that's probably going to happen for a lot of returns.
Okay, all right, thank you.
All right, any other questions? If not, thank you all for joining us this morning. We'll go forward to the next measure. This is Senate Bill 565, and it is relating to alcohol. Expands the definition of beer to specify an alcohol by volume of no less than 0.5% and to include alcoholic seltzer beverages. May we hear from the Department of Taxation?
Chair, Vice Chair, members of the committee, we stand on our testimony, providing comments available for question. Thank you.
Okay. Tax Foundation of Hawaii.
Thank you, Chair. Tom Yamachika from Tax Foundation will stand on the written testimony and be available for questions.
Okay. We have testimony and support from the Kauai Beer Company, from Maui Brewing Company, from Beer Lab Hawaii, from Hawaiian Craft Beer Brewers, I'll get it right in a minute, Guild. We also have testimony and support from Hanakoa Brewing Company, from Kahola Brewery, from Mahalo Ale Works. We have testimony in opposition from the Wine Institute. Testimony.
Hello.
Yes, Mihoko.
Hi, yes, I'm here. Mihoko Ito on behalf of the Wine Institute. Just wanted to make some brief comments. You have our testimony, but we wanted to point out that the way that this bill is drafted will create some inconsistencies with the current law and also some questions because the term alcoholic seltzer beverage has not been defined anywhere else in other states or in other federal laws. And so, in our testimony, we point out what the implications are of those inconsistencies and would just encourage the committee to look at the conflict between the proposal to include this compared to the existing law for other categories. Thank you. I'm happy to answer questions.
So, Mihoko, let me see if I understand your position. If the term alcoholic seltzer beverages were either defined or delated, then you would have no problem with the measure?
Yeah, yes, I think so. And I think it's the way that it's defined that's of concern, because some of the categories are percentage of alcohol based. But and there is an existing definition, for example, for cooler beverages, which, you kind of think, what's the definition, what's the difference between a cooler beverage and an alcoholic seltzer beverage? So you kind of have to really look at those distinctions. In the case of cooler beverage, there's an alcohol by volume maximum. But in looking at the way alcoholic seltzer beverage is currently defined, it could include a product that you wouldn't conceive of being an alcoholic seltzer beverage necessarily, like the Four Loko Blue Raspberry bubbly drink that has a 14% alcohol by volume. And I don't think that's what's intended necessarily. So we just wanted to point out that inconsistency.
Okay, thank you. Let's see. We also have Big Island Brew House in support, Joshua DeMello in support, and Joe Lorenzen. Is he on the Zoom? Okay.
Aloha, Chair Baker. This is Garrett Marrero. I didn't hear my name called, but I am here. I'd like to speak on that issue.
Okay. If you would also send us your written testimony, because we did not receive it, but please go ahead and provide comments.
Thank you. I submitted my testimony under Maui Brewing Company, so it is there. I heard you call that, but I thought they were calling for the verbal portion. But just in the interest of time, I'm going to stand on the written testimony, and just following on to the Wine Institute. I agree technically with her interpretation. However, seltzers are considered what's called an FSB or FMB. Those are fermented sugar beverages or fermented malt beverages. So seltzer, although a broad category, can be made with multiple types of alcohol. We're open to amending the definition, the wording, if we work with the Wine Institute. However, the Internal Revenue Code does define a fermented sugar beverage or a fermented malt beverage as beer. TTB, the Tax and Trade Bureau, defines beer as malt, hops, or beer fermented with grain, hops, water, and yeast. So under the Federal Alcohol Act, the FAA, not the one with planes, seltzer is considered an FSB and therefore a beer. But because the way Hawaii defines malt beverage as beer, it doesn't really give a place for what is now a huge category, which is the seltzer world. So while I think the testimony from the Wine Institute is partially correct, I do think we have some room that we can, of course, work with them on a definition that suits everyone. There are wine-based seltzers, and there are malt-based seltzers, and there are sugar-based seltzers, right? So all of the latter two, the FMB and the FSBs, are seltzers and defined as such by IRC as beer. So that's what we're trying to accomplish so that we don't have inconsistencies with our the storied liquor control at each county. So we want to make sure that we're in complete compliance.
Okay. Thanks, Garrett. Any other comments?
Thank you.
Okay.
This is Joe Lawrenson of Waikiki Brewing Company.
Okay.
I am present. I just wanted to stand on my written testimony.
I don't know that we have your written testimony, so could you? We do have
You do. You called my name a moment ago.
Okay.
It
Okay.
took me a moment
All
to
right.
click on the make my video live.
Okay. So is Joshua Wong? I'm sorry, Joshua Kopp on the call and wants to comment?
Yeah, I'd like to stand by my written testimony.
Okay. Thank you. What about Cindy Goldstein?
Good morning, Senators, and Senator Baker, Senator Chang. I'll briefly review our testimony in support for the Hawaiian Craft Brewers Guild. We do represent the breweries making 100% of their beer in the state of Hawaii. And we see this as something that provides economic opportunity in a time when the breweries are struggling to have new sorts of ways to derive revenue. So expanding the definition puts us more in line with federal definitions and also provides an opportunity perhaps for additional taxes for the state of Hawaii, for gallonage tax and excise tax as production is expanded for these other types of beer ingredients and the fermented seltzers. Thank you for the opportunity to provide testimony and support.
Okay, thank you. What about Nicholas Wong? Okay. Is there anybody else on the Zoom that I may not be able to see or miss that wants to comment on this measure?
Hi, Senator. My name is Steve Humschild with Lani Kai Brewing Company. I didn't hear my name or business name called in the testimony, but I stand in support of adding the definition of seltzers, and thank you for the opportunity to testify and meet with you guys today.
Okay, thank you so much. Anybody else? Members, are there any questions on this measure? If not, thank you all for joining us. And let's move forward to Senate Bill 223. This measure is relating to contracting, requires contractors and subcontractors to submit tax clearances as a condition of 1, obtaining building permits for private developments exceeding a certain value, 2, assigning a contract for private developments exceeding a certain value, and 3, obtaining final inspection of private developments exceeding a certain value, authorizes the Department of Taxation to require that tax clearance applications be submitted electronically, establishes penalties, and appropriates funds for grants and aids to the county. Let's see. Department of Taxation?
We stand on our written testimony, providing comments available for question. Thank you.
Okay, thank you. Honolulu City and County Department of Planning and Permitting submitted testimony in opposition. Tax Foundation of Hawaii, Mr. Yamachika.
Yes, thank you, Chair, and members. Tom Yamachika from Tax Foundation. We've submitted written comments with some technical concerns. I think the primary practical concerns we have are these. One, adding this requirement would probably further burden a process that's already fraught with delays and is already, through no fault of the state, I don't think, a very, very slow and time-consuming and expensive process for all concerned. The thing that worries me most is the requirement that the permitting agency verify that all subcontractors have tax clearances. I'm not sure how they're going to do that with the information that's now submitted to them. And in addition, sometimes subcontractors are swapped up during the build process, sometimes because a subcontractor who initially started the job goes bankrupt and can't finish it. If that kind of fact pattern is present and you require the bankrupt subcontractor to submit a tax clearance as a condition to final approval of the project will never be finally approved. So in circumstances such as that, we think that the permitting agency should be given either some flexibility or that the requirement should be drastically changed.
Okay, thank you. Let's see. Is Mr. Lyons on the Zoom? Subcontractors Association of Hawaii. Testimony in opposition?
Hi, Chair. Mr. Lyons is not on the call.
Okay. Members, we have his written testimony. Any questions for any of the testifiers that are on our Zoom call?
Sure, can I ask tax?
Sure. Senator Riviere.
Hi, Department of Tax, please. From tax office position, what is this bill solving? Is there a problem that, what is the great problem that needs to be solved by this measure? I know tax has comments and not really taking a position, but I'm just trying to understand the underlying problem and whether it's
not their bill.
Because we have opposition of, from just about everybody, but nobody really supporting it. I'm just trying to see what we're fixing.
Senator, it's not their tax's bill.
Okay, but
So they may not be able to comment.
maybe they cannot comment on that. Okay, thank you. We'll leave it there.
Did you want to try to comment in response to Senator Riviere's question, or?
Oh, I'm sorry, Chair, members of the committee, and Senator Riviere, I didn't quite get the questions. There's some glitches with the volume, but we just providing comments, and we just appreciate that we were allowed to require electronic filing of tax clearances, because that would streamline our process.
Okay.
Okay,
thank you. We also have late testimony from the Building Industry Association of Hawaii in strong opposition. They think that the measure is extreme. Anybody else wishing to comment on Senate Bill 223? If not, let's go forward to Senate Bill 601 relating to roofing contractors. This would prohibit roofing contractors from offering to pay in any monetary form an insurance deductible as an incentive to encourage the insured to hire the contractor. Allows insureds to rescind contracts with roofing contractors within 5 business days of receiving notification from an insurer that all or any part of the claim or contract is not a covered loss under the insured's insurance policy. Allows the contractor's licensing board to revoke, suspend, or refuse to renew a contractor's license if the contractor performs as a public adjuster without a public adjuster license. For this measure, we have DCCA. Candace Ito? Candace, are you there?
Hi, this is Neil Arita. I'm the Legislative Committee Chairperson for the Contractor License Board.
Okay.
And
thanks, Neil.
Yeah, we stand on the written testimony and available for any questions.
Okay. National Association of Mutual Insurance Companies, Christian Rataj offered testimony in support. Roofing Contractors Association of Hawaii, Mr. Lyons?
Yes, I'm here.
Would you like to testify?
Sure. I was pressing every button I could find on the last bill when you called my name, and none of them seemed to work. So, but you have my written testimony. I think on this particular bill, we are in opposition. There are a number of issues with the bill. First of all, it only applies to roofing contractors, but roofing contractors, amazingly enough, are not the only ones that do roofs. Sheet metal contractors, structural steel contractors, and general contractors also do roofs, but yet it does not seem to apply to them. There is a 5-day rescission period called for in this bill. There is already a 3-day rescission period that applies to all door-to-door sales. And I've seen or heard of no evidence that says that it ought to be longer. It also talks about that the only time this bill applies is when the consumer is going to use insurance proceeds in order to pay the bill. And we're not sure how anybody knows that. Typically, when you have damage, you call somebody out to take a look and you figure you're going to have to get it fixed. You also call your insurance agent. The insurance agent will maybe tell you what he thinks, but ultimately it's the carrier that makes that decision. A 5-day period means people are going to wait at least a week to get it fixed, if not longer. The only part of the bill that we sort of agree with is that a roofing contractor should not act as a public adjuster. However, there is, of course, also a licensing section in HRS on public adjusters with a prohibition You cannot act as a public adjuster without a license. We're not sure if that needs to be duplicated, but we have no objection to that particular part of it. We do think that one of the keys to this bill is that we've heard of a few other handful of states that have something similar. However, they are all states that do not have the same regulatory structure for contractors that Hawaii has, including the board and its disciplinary process, as well as RICO, which of course, as you know, also does a lot of that. The last time we checked with RICO, they had 0 complaints in this area. So based on all of that, we oppose the bill. Thank you, Chair.
Okay, thank you. Anybody else wishing to offer comments on this measure? If not,
Chair.
Yes,
Matt Fujimura on behalf of State Farm.
okay, go ahead.
We'll just stand on our written comments. Here to answer any questions.
Okay. Let's see, any questions for State Farm? If
I have
not,
a question
yes.
for Tim Lyons, though.
Okay, Senator San Buenaventura. Mr. Lyons, question for you?
Is he still on?
Yes.
Yes, he's there.
Okay, Mr. Lyons, I looked at your written
Yes.
testimony. It doesn't seem that you oppose the first section, which is a roofing contractor shall not advertise or promise to pay or rebate a property insurance deductible.
Yeah, no particular problem. I mean,
It's the rescission part that you folks have a problem with.
it's the rescission and it's not knowing how the bill is going to be paid, and the fact that it applies only to roofers when other people do roofs.
Okay, thank you.
Okay, let's see. Any other questions on this measure? Okay, let's move forward to, let's see, that was 601. The last bill on our agenda this morning is, why is it not opening for me? Senate Bill 576 relating to used motor vehicle parts, catalytic converters in specific. Let's see, we have written testimony from the Department of the Attorney General. Let's see. They have concerns about Section 4 of the bill. And some other comments. American Property Casualty Insurance Association, Mark Setnan, Vice President, offered some comments in support. Anybody representing that organization on the Zoom? NICB offered testimony of support, saying that the theft of catalytic converters is on the rise. We have testimony from Alicia Maluafiti. Is Alicia on the call? Okay, we have her testimony. She says they recommend amending the bill to allow safety checks to be approved even if a catalytic converter is missing, to give the owner enough time to save up the money to replace the catalytic converter. Owners would get one pass on the inspection and would need the part replaced by the next safety check. We have late testimony from the City and County of Honolulu's Department of Police, supporting Senate Bill 576. Says currently officers are ill-equipped to conduct enforcement in this area due to the lack of strong legislation that addresses this issue. Changing the classification of this offense to a felony will help curb the increasing proliferation of this crime and lead to a decrease in incidents. That was signed by Captain Paul Okamoto, Criminal Investigation Division, and approved by the Chief of Police. Anybody else? Members, any questions on this measure? I think this brings us to the end of our agenda. So let's take a brief recess and see if we can do some decision-making. Recess. Okay, we will call the Committee on Commerce and Consumer Protection back to order for purposes of decision-making on this morning's agenda. Members, on Senate Bill 525, after listening to all of the testimony and the concerns raised, the chair recommends that we defer this measure indefinitely. Any questions or comments, concerns? With regard to Senate Bill 562, this is deceptive trade practices. Chair recommends that we pass this with amendments offered by OCP and some technical non-substantive amendments that have been identified by SMA. I would like to note in the committee report the AG's concern and request that JDC, which is the appropriate committee for such questions, address the issue if they hear the measure. Any concerns, comments? If not, on Senate Bill 562, chair votes aye.
Senator Chang?
Aye.
Senator Misalucha?
Aye.
Chair goes aye. Senator Revere?
Aye.
Senator Ventura?
Aye.
Senator Vela? Aye. Motion is adopted.
Thank you, members. On Senate Bill 193 relating to equitable gender representation on corporate boards, Chair recommends we pass this measure with amendments, taking the Hawaii Commission on Civil Rights' recommendation regarding terminology and Bregg's concern regarding the scope, and adjust the first reporting deadline to 7/1/24 and the second reporting deadline on and adjust the second reporting deadline accordingly, and make the date of its effect as 7/1/2021 to provide certainty as to the effective date. The original bill was effective upon approval. I think that's difficult for compliance purposes. So if we set a specific date, it should be easier. So any questions or comments? So the recommendation is to pass with amendments. Any questions or comments? If not, Senator Nishihara, please take the roll.
Okay.
Chair votes aye.
Okay. Senator Chang?
Aye.
Senator Misalucha?
Aye.
Nishiyar goes aye. Senator Revere?
Aye.
Senator San Ventura?
Aye.
Senator Rivera? Reservations? Motion is adopted.
Thank you. On Senate Bill 201, requiring domestic and foreign corporations to provide their shareholders with reports of independent expenditures and political contributions. I think there were a number of concerns that I do not believe we have the ability to address, so the recommendation is to defer it indefinitely. Senate Bill 201, defer indefinitely.
Okay.
Any questions or comments, members? On Senate Bill 320, this is relating to tax return preparers. Chair recommends that we pass this measure unamended. Any questions or comments? If not, chair votes aye.
Okay, was that 220?
320.
320. Okay, got it. Okay, Senator Chang?
Aye.
Senator Misalucha?
Aye.
Nishiyar goes aye. Senator Revere?
Aye.
Senator San Ventura?
Aye.
Senator Favela? Reservations? Okay, motion is adopted.
With regard to Senate Bill 565 relating to alcohol, Chair recommends that we pass with amendments to put an effective date of January 1, 2022 as requested by DOTAX. Any questions or comments? If not, chair votes aye.
Okay, Senator Chang.
Sorry, aye.
Okay. Senator Lucia.
Aye.
Senator Nishar goes aye. Senator Revere.
Aye.
Senator San Ventura.
Aye.
Senator Favela. Reservations. Okay, motion is adopted.
Senate Bill 223, this is the contractors. My original recommendation is to pass it with amendments to insert an effective date of 1/1/2022 for the tax clearance, and make the license effective for 2 years and obtain a tax clearance at the same time they are getting their license. I would want to put a repeal date on it for 12/31/2026 so that it has to come back to the legislature for review. This measure would codify what DOTAX wants to do, which is to have the contractor's license renew at the same time they get their tax clearance. So if you are fine with this, we will send it over to Ways and Means and Judiciary. I also have the opportunity of recommending that we defer it until the 9th to try to get some clarification about the appropriateness of including grant and aid funds to the counties in this measure. What's the committee's pleasure?
I'm for deferring it to find out about the grant and aid.
Okay. Okay.
I echo those sentiments.
Okay, members, we will defer action on Senate Bill 223 to Tuesday, February the 9th at 10:30 in this conference room 229. Okay, I will go talk to the chair of Ways and Means. It is his bill. Let's see, the next item on our agenda is Senate Bill 601 relating to the roof contractors. Chair recommends that we pass this measure with amendments, keeping the 5-day rescission. I want to see if, as it goes forward to JDC, if there's a way to make it the uniform standard. I think I would prefer that rather than having different dates. Delete the language regarding public adjusters, as that's addressed in another bill, Senate Bill 1096, which has a single referral to this committee and will be heard. I want to address the issues with the definition of roofing contractor on page 7, line 20 to page 8, line 10, as I don't believe we want roofing contractors to perform work outside of the contractor scope of practice. So we need to adjust the language, and there are some technical non-substantive amendments. Any questions or comments from members?
The only thing that I can say is that exactly what the guy's saying from the roofing, if we could add anyone that is doing roofing work, like that would be subject to all of this, because we're only definitely in roofing. But if I do roofing, plumbing, I can do roofing, and then I can solicit what these guys are trying to stop soliciting for me for my insurance. I think would be anybody that's doing any kind of roofing work.
Has to be licensed.
Yeah.
Yes. That's definitely what is supposed to be the practice, and we will figure out a way to emphasize that. Thank you, Senator.
I can support that.
Any other questions or comments, members? If not, the recommendation is to pass with amendments. Chair votes aye.
Senator Chang.
Aye.
Senator Lucia.
Aye.
Nishar goes aye. Senator Revere.
Aye.
Senator San Ventura.
Aye.
Senator Favela.
Aye.
Motion is adopted.
Thank you. The last item on our agenda is Senate Bill 576 relating to used motor vehicle parts. Chair recommends we pass this measure with amendments recommended by the Attorney General and make the measure effective on 7/1/2021. Any questions or comments? If not, Chair votes aye.
Senator Chang.
Aye.
Senator Misalucha.
Aye.
Nisha Hargos, aye. Senator Revere.
Aye.
Senator San Ventura.
Aye.
Senator Favela.
Aye.
Motion is adopted.
Thank you. Do we have any business before the committee tomorrow? Yes, we do. We have a hearing, right? 9:30. Is that right? 9:30? Okay, members, we will see you all tomorrow at 9:30 in this conference room for another hearing. Thank you so much for your presence. Thank you, Senator Chang, for joining us virtually, and we are adjourned.
Thank you.
Thank you.